Hi, everyone. We're just going to give it another minute or so just to let everyone get in, and then we'll get started. So thanks for being here today. Okay, so we'll get started. Thank you, everyone, for joining us today. Just a few housekeeping notes. The slide deck can be found in the handout section on your webinar toolbar. Please use the questions section on the right-hand side to ask questions throughout the presentation. We'll be holding all questions for the end. We understand that we may not be able to cover them all during the Q&A section, so we appreciate your patience. We will also be sharing the slides and the presentation video recording link following the live presentation. All right. So I'd like to introduce our speakers today. First, we have William Kinney. He is part of our real estate services team here at Withum. Next, we have Donald Clarke. He is an attorney for bankruptcy and restructuring at Wasserman, Jurista Stolz. And we have Ken DeGraw. He is a partner, the lead of our financial distress and recovery services at Withum. So with that, I will hand it off to our presenters for the day.
Well, thank you, Alex. Welcome, everyone. Great to be here this afternoon. We've got a handful of topics we want to try and cover this afternoon. And certainly, as Alex mentioned, if there's something that is on your mind that we're not covering or that we don't cover deep enough, that you've got something specific, certainly put it in that chat function or the questions rather, and we will get back to you if we're not able to handle it during the course of the program. We will certainly reach back out to you and try and get you an answer. So we appreciate your time and attention. We're gonna start out by just taking kind of a broad look at the industry and what's going on out there, what we're seeing from an industry perspective. Then we'll go into some of the bankruptcy and distress issues that both landlords and tenants need to be conscious of if they're either troubled or perhaps have tenants that are troubled. Maybe some things they could be thinking about doing now versus what may happen later. And then certainly we'll go through some at a really high level, some of the aspects of landlord and tenants within a bankruptcy proceeding, just so everybody has an understanding of what goes on. And then finally, we'll deal with the application of law to some of the current issues that have been confronting folks as they approach some of the venues. So with that, I'm going to turn this over to Bill to talk about the industry and what's going on.
Thank you, Ken. And hello, everyone. Can't see you, but you can see me. As Alex mentioned, I'm in our real estate group. We handle all sorts of real estate entities in scope and size, from the tiniest little LLC up to REITs that include literally dozens or even hundreds of assets under management, often into the billions. But I have a couple of clients that, a mom and pop that have an LLC that own an office building, and unfortunately, this has affected everyone. Now, how is it affected and who and where? Unfortunately, the answer to that is it depends. Both tenants and landlords. If you're in the distribution center business, you're doing pretty good right now. If you're in retail, restaurants, and otherwise, in some parts of the country, you may be looking at some rough stuff. So what I'd like to do is take a few minutes to talk about the tenant side of the page, as well as the landlord side of the page, and how there's a lot of overlap in between, especially as it relates to what's going to happen going forward. Use some technology here to my advantage. Well, maybe not. Ken, if you'd flip that forward, that'd be great. So we have a couple of topics here: amenities, the office, and the concept of space versus distance. And from a tenant standpoint, amenities are not what they were just 12 months ago. Gyms and common areas and all those sorts of things, those are on the back burner for the foreseeable future. An amenity now is having a walk-up office on the second or third floor. As if you think about it, and you're in a high-rise office building that can hold, hundreds or even thousands of people, it's pretty difficult to get everybody up at 2 at a time on an elevator. So lower floors have become an amenity, as crazy as that may sound. I mentioned gyms and common areas and those sorts of things. Those amenities, and I'll put on my landlord cap for a second, in a lot of places are being repurposed. Big spaces that have been used for, exercise or common area activities or coffee shops or whatever you want to call it, can be repurposed into conference rooms or multiple conference rooms that offer a lot of space. And we've seen that all over the country, especially in major metropolitan areas. Obviously with lockdowns and things like that, people are not necessarily going to the office, but those that are, and those that are essential and those that need to, are demanding more space. And there are conversations ongoing between tenants and landlords to make that happen. Another big amenity that's looking forward is landlords managing the compliance process or managing the lockdown and or restriction response. If landlords can provide at least a modicum of assurance, it will certainly make the transition back to the office easier, because unfortunately, from county to county, town to town, state to state, restrictions and rules have been changing. The number of people that can be dense in a particular room, what does it look like? How is security for buildings being managed? All of those things. For example, I'm in our office here in Bethesda, and just as you walk in the door, there's a handful of things that we need to do just to get in the building. And the landlords have made a big point of offering that first layer of comfort or assurance that not only is the building clean and the air filtration system is clean, but just using the elevator, using the door, the littlest things make the biggest difference. Amenities and getting in the door, or being able to use the things that are not in your office, then transition into the office. Now, what does that look like? Well, we're using GoToWebinar right now. I heard something recently, literally yesterday. Approximately 12 months ago, there were 25 million Microsoft Teams users. Now there are 125 million Microsoft Teams users. It's pretty staggering if you think about it. Fortunately, Microsoft can handle it, but how many offices have closed and have said, we're closing permanently and everybody's gonna be remote from now on? Well, what do you do about that? Well, what do you do about this existing space? And for those folks that are gonna keep the space, what are they gonna do with it? A big trend that started in the early 2000s was the idea of the open office concept. And that's probably going to go away for a while. The idea of cubes and offices and those sorts of things are suddenly very appealing. And interestingly, from a commercial office standpoint, real estate that has not yet undergone a transformation into the new open space, or hasn't had a build out recently because they've had a long-term tenant, is now very attractive. And I've seen people move literally across the street into an older building that has not been refurbished because they have what's an old footprint or an old layout, which is, ask me that question a year ago and tell me that that's a good idea, and the answer across the board would be no. No one would do that. Another thing with the office that's happening is same footprint, but less space. So let's say we're not necessarily gonna undo all our open office ideas, but how do we make the office comfortable for people to come back to it? Now, hopefully with the vaccine and everything that's coming, this may be something we don't have to worry about in the hopefully near future. But in the meantime, as we continue to open up the economy and people are back to work, how do you encourage people to come to the office? Do they want to come to the office? How do you make them feel comfortable about it? And rearranging the space from what you have into what you need to make it to offer more space in between, space versus distance, in between your folks is a big piece and part of it. And what can landlords do to incentivize perhaps a mid-lease build out to help make that happen? So at the end of the day, what's the big question is, how long is this going to take? And how long before people are comfortable coming back to the office? No one knows the answer to that question. When it comes to retail and otherwise, that's the biggest wild card. There's some retail that's continued to flourish depending upon what part of the country you're in, and there's other retail that frankly is gone. Unfortunately, in this area, there have been quite a few businesses that I used to patronize that have simply closed up shop. They've either said, nope, we're just going to shut it down, or they're gone completely. Unfortunately, 4 lease signs are in a lot of retail centers now. From a landlord perspective, if you'll flip that forward for me, Ken. Same concepts. Oh, there we go. Same topics, a little bit different perspective. From the landlords, are you listening to your tenants? Are you partnering with them? Are you trying to figure out a way to not blow it up, to not terminate the lease, to not have an eviction? How can you make this happen? Landlords certainly have to pay the bills, have to pay the mortgage. They have to do what they need to do, and they need the cash flow to do it. But is there a way to manage that? We'll talk more about what happens if you can't manage that in a few minutes. But what conversations are happening? How many people are reaching out to their landlords? How many landlords are reaching out to tenants? If anything, just to take their temperature, to try to figure out a way to make this happen. We happen to be in an office building, multiple, different firms are in this building. We've kept it, of course. We've been essential throughout, and we're going to need it going forward. So we're not going anywhere anytime soon. But there are certain businesses that's just not a feasible option. From an office perspective, can a landlord not just think about how do we make the layouts change right now? How do we change build outs right now? But without a crystal ball, how are we going to look into the future and make that a little bit better? What are we going to be able to do to make it attractive to potentially new tenants going forward? What is tenant allowance going to look like? And what is tenant improvement allowance going to look like? More wild cards that no one knows the answer to right yet, but the short answer is it depends. Market to market, state to state, county to county. It's different. It's different everywhere. There has been some pushback from tenants to landlords, and I've seen and heard this of tenants that are potentially multi-state and have rules applicable to a location in a certain place, and they're leveraging those rules in another place. And it's created a lot of angst and conflict with the landlords. So the most important thing, and it's no different than I tell my children, tell me, talk to me. Let's communicate about it, because that's how we make things happen, and that's how we make improvements and make changes. And I think the only way that tenants and landlords are going to be able to come out of this together is to work together. I'll pause for a moment. I can see Don's chomping at the bit to jump in with me.
I'm just actually, as you're speaking, I'm just recognizing all the scenarios where it's actually everything you're discussing is playing out in real time in bankruptcy. So I don't want to jump too far ahead about some of the current trends.
Sure, we'll get there in a few.
Yeah,
it's I have clients that are landlords that own commercial property, and a big conversation that's been happening is a modification of the lease, at least in the short term, for some sort of revenue participation. At least there's a floor of some kind, and then at least the landlords can get something and the tenants can stay in place. And that's a good example of partnering. Just throwing up their hands if you're a landlord and demanding every dollar may not be viable. Also, throwing up your hands as a tenant and throwing it and saying, nope, I'm not giving you a dime, may not be viable. Hopefully there's something in between. Unfortunately, there are situations where neither is possible, but hopefully there's a lot of conversations going on. I can speak to my clients, and they are having conversations weekly, sometimes daily, with tenants all over the country. Generally speaking, the middle of the country seems to be managing a little bit better. Major metropolitan areas are where things have been hurting across the board: commercial, retail, mixed use, and what have you. The only thing that necessarily hasn't been hurting is residential, especially multifamily. That's been doing incredibly well. But other than that, it really depends. And that's the refrain: it depends. Conversations I have with clients, the answers become, it depends. So if you hear me say that more than a few times, it's not a matter of being redundant. It's just, unfortunately, the way we are right now. I think Ken's very excited to jump ahead. And I'll turn it over to him.
Is that my cue, Ken, to start hitting some proactive steps? All right, so thank you everyone for joining us. I'll try not to make this too dry because I've got some, I guess bankruptcy specific legal issues. Most of them are pretty basic, but very similar to what Bill was saying. Any attorney who really knows what he's talking about, the first thing he's going to tell you when you ask him a question is, it depends. And it's going to depend on the jurisdiction you're dealing with, where the real estate's located, where the debtor's filed, or where the lease clause specifies applicable law. For proactive steps, generally, the first thing you're going to do, whether you're a landlord or a tenant, is make sure you find your lease and review the lease. You'd be surprised how many people can't find the lease. In most instances, with some of these bigger cases, and a lot of the cases we're seeing now are retail, obviously that's all in the news, restaurants and gyms, for all obvious COVID-related reasons. And retail was hurting even before COVID hit. So we'll get into some of the current trends and how they affect, and this pandemic has affected bankruptcy specifically. But the first thing, whether you're a tenant or a landlord, presumably these really apply when you're a landlord. Some of the things that you should look into are look in the lease, be familiar with the lease, know your rights in the lease. Some of the leases that my clients have go back 90 years, 80 years, and they've been constantly, amended or carried forward. And there's, there could be up to 10 amendments or even more, as many as you can imagine. Make sure you understand which provisions are still applicable. When you look at non-financial information, understand what your deadlines are, how long your tenant has to react to your request for information or your demand for a rent payment, something along those lines. You have to know where you stand in relation to your tenant or your landlord, for that matter. Security deposits or letter of credit or cash. This we deal with a little bit later, but in short, security deposits are generally, when they're cash, part of a bankrupt estate, so you can't touch it in most circumstances. So you'd probably favor going to a letter of credit where you can draw down without being subject to the bankruptcy court oversight. We'll get into that a little bit more in the future, but you want to understand whether or not you've got a security deposit in cash, whether or not you've got a letter of credit, whether or not you've got those documents located, and you understand whether or not that letter of credit is still good. Guarantors, understand whether or not you've got a guarantor on the lease. In some circumstances, when you've got a debtor who files, the guarantor entity is going to file as well, and it's really neither here nor there. But sometimes you may have a an individual who's a guarantor, and they're going to be less. Usually, that guarantor is the principal of the company, and if you've got a small, one or two shop footprint, they're going to try, obviously, to avoid filing themselves. But if they're a guarantor on the lease, they might be stuck for some of the obligations. Proactive engagement. This depends. When you've got some of the larger cases that you see filing now, you can try and reach out to the debtor, your contacts at the debtor, or in some instances, they have a firm that comes in and starts to manage the real estate properties, figure out what their status is, who's behind in rent, how much they're behind in rent, and really whether or not those leases are above and below market. They'll do that in analysis for the debtor, because the debtor is going to want to know whether or not they're going to want to keep these leases in the bankruptcy, or sell them or reject them outright. So you're going to want to know for yourself whether or not your lease is above or below market. Nowadays, you're not seeing too many leases that are spectacularly below market. The market is pretty depressed. And proactively declaring a default or request a modification. Again, in some circumstances, when you're dealing with, say, a GNC or 24-hour fitness, you don't have much bargaining power, or your leverage, your threat to bring them to court is not as extreme as if you've got, some landlord who owns a couple spaces, or really one strip mall, and you're one out of 8 stores in that strip mall. They obviously want to keep it as full as possible. In that circumstance, you know, you may be in a situation where if that is that store's only location, evicting them will put a serious damper on their ability to conduct business. But when they're one of 1,500 stores, it's just going to be thrown in the pile of all the other delinquent operating sites. One of the proactive steps I've seen online and that in trying to put some stuff together for this webinar I saw was making additional loans to the tenant inside or outside the lease. I'm still not clear on how that would help anyone, and there's a landlord here who's trying to protect themselves and thinking of doing something along those lines. I would not recommend it nowadays, and we'll get to the assumption of rejection and bankruptcy soon. But all that would do is make the debtor more likely to reject your lease because it makes your cure obligations all that more onerous. Now, if you want them to reject it, perhaps that's a strategy if you could see it that far in the future, but ultimately that's going to leave you with a pre-petition claim, and you get paid on that in bankruptcy dollars, and that's not likely to bring back a significant return. Especially nowadays when a lot of these larger cases, if you're a tenant, if you own a strip mall with some of these larger cases, these GNCs or Craftworks and debtors like that, you're not going to be likely to see much on a pre-petition claim. So many of these larger cases are just administratively insolvent because the circumstances are pretty dire out there. Again, a lot of these big chain operations have already been sucking wind, and when COVID hit and they couldn't bring anyone in, they certainly couldn't generate any revenue. So if we can go to the next slide, this is bankruptcy for a tenant. Here's some more dry things in terms that you should probably understand when you're dealing with a bankruptcy. The first is one of the most important terms that you should understand. It's called the automatic stay. When a debtor files bankruptcy, they're protected by the federal automatic stay. And what that does is stops every creditor in their tracks from collecting on a debt or initiating a suit or anything else. It is the most powerful weapon in a debtor's toolkit. The creditor can petition the court and move for what's called stay relief, and essentially trying to assert its rights, but it has very limited ability to do anything initially in the case, and they're usually put on ice for at least a couple months, unless there's some cause that you can show that you as a creditor are being singled out or particularly harmed. The next is get informed, be proactive. That kind of goes back to the proactive steps that you were trying to probably take care of before a bankruptcy was filed. At this point, if the bankruptcy was filed, there's not much else you can do. You're now in the system and you're kind of going along for the ride. You can be proactive, like I said, by this time. Sometimes these big debtors will have a management company before they file so they can assess their leases going into it. Sometimes they retain them anew in the bankruptcy case, and they haven't actually engaged them prior. So your best bet is obviously to reach out to your normal contacts and see what's going on. What are they planning for your store, for themselves? There's some documents on the court's docket that'll get filed that you'll be able to try and glean some of that information. But beware, you're being fed a line that the principal that you're talking to, that the contact you're talking to, is fed by his attorneys, and most of the time that line is aimed at giving the debtor more time to figure out what it wants to do or has to do. Usually from the beginning they understand there may be a couple options and they're not sure which is going to work out best, and you're not going to know until you're a few weeks steps into the case. So there are plenty of times where I've heard my landlords being told, oh, don't worry, we're going to go forward with your space, we're going to reopen, yada, 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 and it never comes to fruition. Again, they are going to be protecting the debtor at large and the constituency at large, and you are only usually one of many creditors in the case. So to the extent one individual creditor gets harmed, especially when you're dealing again with some of these larger cases, The courts don't have much sympathy, and if they do, they feel like there's not much they can do because there are so many other people who could stand to gain some recovery, frankly, at your expense. So confirm the debtor and the lessee are the same. Clearly, you want to make sure that you are going after the right debtor. Sometimes these debtors have multiple holding and affiliate companies that will file. You have to make sure you're filing your claims, and we'll get to a proof of claim in a minute, against the proper debtor, because that can kill your chances of any recovery or distribution in the future if you do that wrong. Default before the bankruptcy. So defaults before the bankruptcy, that kind of ties back to your proactive steps. If you understand that this entity is having an issue, this tenant's having an issue, the chances are they're going to continue having issues, especially when they're a national type debtor. So if they default, unless and this used to be an issue a while back, I'd noticed a lot of my landlord clients would just want to keep someone in the space. The more dark you have in your strip mall, the less appealing it looks like to anyone else. And that's going to be a business decision for any individual landlord, and it's going to depend what your makeup in this individual location is. But for the most part, if you want them out and there's a pre-petition default, the time to act is pre-petition and try and enforce that default, enforce your rights. To the extent there's a default before the bankruptcy and you do nothing, and then they file bankruptcy, they're still protected by that automatic stay to a great degree. They're supposed to continue to make their payments post-petition, and we'll get to that just a little bit more on that in a bit. But it's not guaranteed that you're going to get that money up front. And quite frankly, when you've got an administratively insolvent debtor, even your administrative claims, which have a higher priority and get paid before pre-petition claims that existed as of the petition date, it does you no good if you're only going to get partial payment and they tell you have a pre-petition claim or a post-petition administrative claim. But, oh, guess what? There's no administrative money to pay because it was just that bad. And that entire time you're sitting there holding your empty space in your hands. So again, they must remain current post-petition. In my notes, I have laughable written down next to it for just that reason. An administrative claim in an insolvent case is worthless. So you cannot offset cash security deposits. This is what I discussed before, touched on briefly with the letter of credits. A cash security deposit is held by the landlord, but it is actually what they call property of the estate, the debtor's assets. And you can't offset any arrears that you may be holding or may have on that property against that tenant, against that cash security deposit without getting authority from the court, which means you're going to move for stay relief and ask them to offset it, unless they're already rejecting that lease, and we'll get to rejection and assumption. There's no way that a court's going to let you do that before the court has taken its cue from the debtor and figured out and allowed that debtor an opportunity to figure out what they want to do with that space. And ipso facto clauses are not enforceable. An ipso facto clause is essentially any clause that says that the bankruptcy itself is a triggering event. We get the space back upon your filing of a bankruptcy, or you owe us another $1 million when you file bankruptcy. That's an ipso facto clause, and they're void. No court will give that any due weight or credence. When a debtor files, the rights and interests of the landlord and the tenant existing as of the filing date are what exists in the bankruptcy as of that filing date. It draws a line in the sand, and no one can pretend that line was drawn anywhere else or try and grab something before that line was drawn because of a clause like an ipso facto clause. Filing a proof of claim. Always file a proof of claim, except when you have a letter of credit as a security deposit. And that really goes into, it's more rare. I mean, there are a lot of landlords who have letters of credit as a security deposit, but I find it's more rare than I would have expected. And if you have a letter of credit as a security deposit, that letter of credit is not property of the estate. So you don't need to request the court's permission to draw down on that. But you don't want to file a proof of claim, and we'll get a little bit more into detail on the proof of claim later. I'm trying not to jump ahead too far. But one of the claims that you have against the estate is called a lease rejection claim. And it's a statutory claim that's calculated based on it's a statutory calculation based on the amount of time left under the rent and your yearly rent. To the extent you have a lease rejection claim capped and you file a proof of claim, you can't draw down on that letter of credit for more than that capped claim. However, if you didn't file a proof of claim with that rejection damage, then you can draw down on that letter of credit on whatever amount of arrears and whatever amount of damages you're entitled to, as long as that letter of credit covers it. Sorry if I'm going too quickly, but let's go to the next slide if we can. So I'll try and, oh, it looks like there wasn't one before that, though. Maybe that was one that was, no, okay. So that looks like there was all right, I had an old slide in, sorry about that. So here we go. Okay, so Ken, were you gonna be talking about the bankruptcy claim, or do you want me to talk about it?
Sorry, muted myself. Yeah, absolutely. I'll run through this real quick, and then by all means chime in. A landlord with a tenant who's filed will find themselves with 4 potential claims, which is why it's so important to file that proof of claim. I know as a financial advisor, as we're getting those claims in, we're trying to reconcile that with the debtor's books and records, which are sometimes less than pristine. In fact, most times less than pristine. And that information from the landlord in the support that they're able to provide really is invaluable when it comes to making sure that the appropriate everything is put in its appropriate spot. Obviously, you've got to just kind of run them down real quick here. So the rent that's been incurred and not paid up to the point where the debtor filed for protection, that's all a big unsecured claim. So you're in the big bucket with everybody else. And you'll get if it's a good case, you'll get a few pennies in the dollar, hopefully. If from the time the filing happens to the time they make a decision to assume or reject the lease, and I know we'll talk about that in a couple of minutes, so I won't steal that thunder, is the next bucket of time. And presumably that's been paid, at least it's supposed to be. A lot of times it's not. What happens there is that all gets administrative priority, which is a kind of bankruptcy speak. So within the bankruptcy code, outside of secured creditors who are holding specific pieces of property as collateral, everyone else is essentially an unsecured creditor. Within that unsecured creditor body, the bankruptcy code gives 10 separate buckets of priority, of which the administrative claims are the #1 priority. So along with the post-petition rent, the other claims that are in there are typically professional fees that are being incurred in the pendency of the case, just to give you a flavor of where you stand. From the time they reject the lease, assuming they reject the lease, that then just becomes another unsecured claim. And along with that would go, once they reject, they need to leave the premises, and inevitably the stuff is still going to be on site and needs to be cleaned out. So all that removal and or repairing of damage, whatever it might be, that all gets included in the unsecured claim as they exit the property. So in a nutshell, that's the 4 buckets of claims that a landlord's going to have.
Okay. Is this me? I think this is where I got my notes, my personal notes mixed up here. So landlord bankruptcy, where the landlord actually is the one who files, you're still going to have the same rules applying. However, when they're applied and protecting a landlord, there are some differences that landlords and tenants should be aware. We discussed the automatic stay. Getting informed is the same thing. The obligation to pay rent is unchanged if the tenant wants to remain in the space. The issue here is the landlord can essentially reject that lease, and he won't be responsible for providing any services or anything that the lease says he's obligated to do. So you'll have a tenant who doesn't want to leave, and a good example of this is actually back when the Revel was the case of the day. There were a significant number of tenants who didn't want to leave, even though the Revel couldn't operate at a profit. And ultimately, it was determined after appeal that the tenants couldn't be kicked out as long as they continued to pay rent. It didn't make much sense considering then they were in a big empty building trying to get some clientele to come to their restaurants. But in order for that debtor to get them out of the space and ultimately evict them, they would have to, if I recall, they would have to essentially pay them the net present value of that lease. And, you know, it was going to be still no insignificant amount for a debtor to have to pay. And if you don't have the money, you don't have the money. Again, security deposits are not property of the estate because it's the tenants. So the landlord can't take that money. The debtor can then use that money to continue to pay rent if it doesn't want to make monthly payments, essentially. But they should be aware, tenants in this situation, that a landlord might still have some other claim to that deposit and can try and prevent the tenants from using that deposit for rent. Or the landlord, as a debtor, might still have any other number of causes of action against the tenant. If he's damaged the space or some other contractual obligation that he's defaulted on. A landlord debtor would still be entitled to essentially sue that tenant in bankruptcy. The landlord again can assume or reject, and everything that we just discussed is what their rights and remedies would be. They assume it, then they have to continue to provide those services. If they reject it, they don't have to, and the tenant does have to continue to pay rent if he stays there. So the lease, and this is true for both situations, whether the tenant or the landlord is the debtor, the lease can be assigned to a new owner. Before we hop on, I think I'll handle that on the next page for the assumption or rejection. But the last little line there, personal property damages, if any, cannot be offset. And that's true. Basically, any cause of action that the tenant has against the landlord debtor under the lease, if the landlord rejects it, there's no recovery for the tenant in that situation. Again, the tenant's just hanging out there in the wind and will have to continue to pay rent if he wants to stay there. But the landlord's not going to have any other kind of obligations like fixing a water heater that breaks in the space or something along those lines. So I guess, Ken, if we can go to the assumption, assume or reject, I think that's the next slide. Okay, good. So this one is back in order for me. So assumption or rejection of the lease, and we'll take it in the context of a tenant being the debtor and the landlord obviously being non-debtor creditor. As a landlord, you have about 210 days ultimately to find out what's going to happen to your lease in a debtor's bankruptcy. It is a long time to wait. Now, during this time, they're supposed to be paying their obligations in the ordinary course. There is an opportunity for a debtor to request essentially a 60-day additional breathing spell to pay rent. That will give you an administrative claim for that amount. But as we discussed, when you've got an administratively insolvent estate, that's not a very, very valuable thing. However, it has a higher priority, like Ken discussed, than pre-petition claims, which get paid last. When you have an administratively insolvent estate, you're usually then those admin claims are sharing with the professionals, like the attorneys, debtors' attorneys. If you've got a committee, the committee attorneys, the debtors' financial professionals, the committee's financial professionals. If there's a trustee involved, the trustee and his professionals. and quite frankly, the U.S. trustee who gets fees throughout. Everyone gets paid before the creditors, and that's usually just especially the pre-petition creditors, and it's unfortunate for a lot of these creditors who stand to gain nothing, and they have their spaces essentially hijacked for a short period at least. If you can say 210 days is a short period. So within that that they initially have 120 days, they can move to extend that time to make the decision whether or not to assume or reject your lease for an additional 90 days for what they call cause. And it's a very broad definition. Basically, cause can be, Your Honor, we haven't figured out what we want to do with the lease yet, and it's could be valuable, and we could bring some money in to pay creditors, so give us more time. And that's essentially enough. After that 210 days, the debtor can extend further, but only with consent of the landlord. And if a landlord's likely to give that consent as long as they're getting paid in the ordinary course, in order to assume, the debtor has to cure the default. Curing the default means all monetary and non-monetary obligations under the lease that are in default. Any rent in arrears, non-monetary would be there's a lien on the property from a mechanic's lien. They have to get it removed. It's monetary to the debtor, but it's not necessarily monetary to the landlord. He just wants to lien off the space. So he'll have to compensate landlord for all actual losses. And adequate assurance of future performance means that the debtor's going to have to show the landlord, prove to the landlord that to the extent he assumes the lease, he's going to be able to continue paying it. The assumption ultimately is the debtor's contractual obligation ordered by the court to continue operating under that lease, and it takes on the burden of its responsibilities in the lease. It's in order to assign the lease, where it's going to basically, it has to assume it from the landlord, and then it can assign it to any entity virtually any entity that it wants. And we've got some protections for a landlord, like the shopping center protections, which are statutory, which basically have to do with tenant mix and makeup of the space. They're not going to let you put an adult movie store or a bookstore next to, a mom and pop ice cream parlor shop, if that's something that's forbidden in the lease. If they reject, we touched on this before, as a tenant, if you reject the lease of a landlord, you have to vacate the space, and the landlord is given what's called an unsecured rejection claim. And it's essentially as if the lease was breached as of the date of the petition. You get and again, this will depend, like Bill was mentioning earlier, it depends on what jurisdiction you're in. But some courts will allow you to include arrears that hadn't been paid, taxes, CAM, all that kind of stuff. And then also on top of that, your rejection claim. Again, your rejection claim usually amounts to 1 year of the rent under the lease, but it's actually a statutory calculation, and depending upon the jurisdiction you're in, you can do what's called time versus rent approach. But I'll spare you guys the details of that. But that has to do with when you're actually filing your proof of claim. It's very interesting stuff.
Don, let me just throw a question at you. So that we know there's 120 days plus 90. What are the judges doing a soft 90, I'll call it, and kind of really giving the debtors a lot of rope here, going beyond the 90 days, even if the landlords are not happy about it? So
statutorily, what they'll request the actual number of days. Okay, so in the pleadings, they'll request, before that 120 days is up, they have to file that motion to request the additional 90. It's hard on the calculation, but it's soft on the cause. Let's put it that way. They will essentially always get through 210 days. One of the, I don't want to, I guess, skip too far ahead, but one of the things with the practical applications that we were discussing, you're going to have, where it gets real soft are the judges now in light of COVID, allowing debtor tenants to basically push off their rent obligations. And actually on the last slide, the current trends, and I should give a shout out to Mark Conlon. He was on the list of attendees at Gibbons who actually wrote the article that I tried to give the URL for. I think it may be linked to that, but we can give that out. He put together a nice write-up of what happened in the Modell's case and what happened in the Craftworks case, the Pier 1 case, and it basically what ended up happening was you've got a statute that requires these debtors to pay their obligations in the ordinary course. In the case of Modell's had filed pre-COVID. They were going to do going out of business sales in their stores, and COVID hits. The government shuts down access to the stores, so they can't conduct these going out of business stores. You can't solicit people. You can't get the foot traffic. So essentially, it was pretty extreme and extraordinary relief. But bankruptcy courts are a court of equity, and that's why there's so many soft rulings or applications of the respective provisions, because it is a court of equity. So the judges essentially said, hey, look, if you can't get anyone in the store, how are you going to do a going out of business sale? And so they basically put everything on pause. And, clearly everyone knew that couldn't continue ad infinitum. So after a few weeks, months, actually, in some cases, finally the debtors started coming back, and, you had some states who would open up and they would say, well, with these stores, they'll pay X percentage of rent. And with these stores that are still closed, they'll pay a smaller percentage of rent. And it's gonna depend. It's gonna be case by case basis, what kind of business they're in, what state regulations there are on the shutdown. But that is a developing area of the law. And everyone I know in my business is waiting to see how that all turns out. But tolling those obligations was something that you wouldn't have expected to happen, and it hadn't happened before. But with these COVID concerns, it makes sense. Clearly, I represent landlords. They're sitting there saying, well, wait a minute, I'm still giving them access to the space, or I'm letting them use the space, but technically the debtors can't use the space. But you still have these landlords who have to answer to the banks, and there's a whole commercial mortgage industry out there that eventually is going to feel the reverberations from these types of tolling. And there's more ugliness to come, I think, not to be a harbinger of doom. But I guess, should we stay on the current case trends? I have up there also the, with these COVID restrictions, force majeure is a new, it's not new area of law. It's actually quite old, but it's getting some focus now. And that Pillsbury law, they have a website that basically is a good repository for a lot of, not even just, there's few outcomes really, but there's a lot of pleadings being filed, different parties trying to assert a force majeure defense. And it remains to be seen how the judges start reacting to these. But force majeure is essentially a clause in a lease that says acts of God and what have you will prohibits our obligation or prevents our obligation, tolls our obligation to pay rent or take some action. It's again going to depend on the language of the clause and the jurisdiction that you're in trying to assert this. And if force majeure isn't something that's in your lease, then you've got common law or a material adverse change is another type of clause similar. But if you don't have either of those, you've got common law common law defenses like frustration and impossibility. Impracticability is in there. It's really a UCC commercial defense. But there is some bankruptcy law already, some bankruptcy cases already that have come out and said and gone back and said that a debtor didn't have to pay half of whatever the rent was under a proof of claim or going forward because they couldn't use the space. Especially most of the time you see that, especially now in restaurants. But that's really the current case trends. I'm sorry if I hopped around, but I feel like I've been talking too much. If anyone else has anything to add, I'm happy to shut up now.
Bill, you've been seeing anything else on the industry side where folks have attempted a force majeure claim or going against business interruption policies? Anything along those lines? Not that I'm sure many of them aren't having any success, but at least trying.
I've only seen random application of it because, business interruption versus, landlords are pushing back, saying, wait a minute, you got an avalanche of PP. What are you doing? Like, well, wait a minute, why are we at the bottom of the heap here? I haven't seen anything specifically. I've heard of conversations about it, especially in the case of, a multi-location tenant that's across multi-jurisdictions. That's where it gets tricky, restaurant chains, that sort of thing. But generally speaking, not to the extent, but there's talk, so here it comes. If there's noise, then odds are something's going to happen. Especially given that we're potentially going to have more lockdowns happening. Depending, again, it depends on where you are. Lockdowns happening, maybe the conversations that have been put to the wayside will flare up again. So I don't know. What do you think, Don?
What do I think about what the COVID restrictions? I'm sorry. What?
No, just as far as conversations about this may have been happening previously, but as things started to open up and in some cases businesses started to recover a little bit, a lot of this wrangling was put to the side, but now it may be coming back because depending upon where you are, lockdowns are happening.
I think this is probably one of the worser case scenarios of the 1-2 punch. You had that one punch and it laid a lot of people out, and anyone who was fortunate enough to kind of bounce off the rope and start to come back is going to get laid out. I think it's going to be very, very tough. One of my clients now is a restaurant, and it was a very popular restaurant, and it was a great restaurant, in fact. And they had some onerous lease obligations, and a lot of times it's going to come down to the landlord giving some kind of concessions. And in some cases, you do have a landlord who's going to be willing to concede or grant some modifications. But it's always going to depend on what their individual interests are. Again, if they've got a ton of space and they can they figure they want someone else coming in there, or they can get someone else, because there are spaces being eaten up. I do have clients who it's not all bad for them. A lot of times but even before COVID, the medical facility practice was starting to ramp up a bit, and a lot of times those smaller outpatient type facilities were snapping up some space. They have a lot of it's expensive to fit those places up, not just because of the machinery, but everything that they need. But there are, like you said, these smaller footprint mixed use places or buildings. Those are seeing a lot of tenants knocking at the door, because everyone's fleeing these high rises, any of these places with the elevators that the landlords can't make safe enough for a tenant.
It's interesting you mentioned high rise. There's a little phenomena happening, especially in metropolitan areas, where upper floors are being, for lack of a better word, abandoned. Smart folks are gobbling them up and signing long-term leases because they know once the storm passes that at some point there will be a premium on the higher floors again. And if they're able to gobble up a space at a pretty low lease because the landlord is needing the cash flow, then they can sublet that later and potentially do quite well.
Yeah, and so the tenant's going to do well there, but then I question how that landlord's going to do, because that tenant's going to have a terrific under market lease, and then all of a sudden you're going to have this landlord with all under market leases, and it's harder for them they're not going to be able to catch up between inflation and all the other costs. So they're going to keep going up, and they've got a 50-year lease that's 50% of the market.
And the ripple effect there could be pretty heavy. I would hope landlords are going to be savvy enough to maybe stop that in its tracks and have some out clauses and out years to, shall we say, renegotiate.
Yeah, I mean, you usually see them have, they usually have, you know, after so many years, they, you know, the rent's going to go up and all that kind of stuff. You'd be surprised. I'm surprised how many leases are pretty old and antiquated. But you know, sometimes they're just locked into them. But it reminds me back when I went to study in Miami. When I left, it was when the first, you know, housing crisis started, and I'll never forget. I had, you know, classmates who were in, you know, what amounted to then 20-story walk-ups because the elevator services were, the elevators hadn't been serviced and they couldn't turn them on. They had, you know, no AC and all this kind of stuff. It was pretty ugly, but you know, we'll see what happens. I do think that, you know, they've got all these you know, good news on the vaccination front. You know, I've one of the best reports I heard recently, someone was saying that, you know, well, it was good and bad. They said 2024 is when you can expect everything to go back to normal. I thought that was bad because that's pretty far out. I was hoping 2022 maybe, but they said when that happens, it's going to be like the roaring 20s. Everyone's going to be going out and partying, and going kind of crazy to excess because everyone's going to have been locked up for so long. I mean, I already see that now. People, you know, alcohol sales are way up, and you know, it's people are getting, you know, chomping at the bit to get outside, and now they're being told like, you know, they shouldn't go, you know, see friends and family for Thanksgiving. So it's going to be a wild ride, but it's not over yet.
I would imagine next spring, people are going to be running wild in the streets just to get outside again.
So we've got a couple minutes left. There's at least one question I'm being fed here in the queue, and Bill, this one's directed at you because it's an article that you wrote apparently. So I hope you remember. I recently read an article Bill wrote about lessons learned from virtual care. What best practices from other industries should landlords and tenants take under consideration to navigate this black swan period?
Yeah, that was an article that I wrote. It was, you know, how real estate can take some lessons learned from medicine and how they've rapidly adopted virtual care and what they were doing with it. You know, the change in office space as it relates to physicians' offices, that, you know, maybe more space, but more distance, you know, that kind of thing. From a best practice standpoint, there's one. Talk to your landlord, and if you're a landlord, talk to your tenant. Just find out what's going on. Like a lot of things in life, sometimes it's a heck of a lot easier to ask permission rather than beg forgiveness later. If you're begging forgiveness, then you're talking to Don. If you're asking permission, I'm still helping you. You know, I'm working with you. So that's the number one. I know medical buildings. At first, everyone thought, "Oh no, medical buildings are going to be a dead sector, you know, within that space because nobody's going to go to the doctor anymore." Well, that's not true. I took my son to the orthodontist today. It's still going to happen. What is happening is physicians' offices are reconfiguring a little bit, and they're adding a little more space to offer that level of comfort to their patients, for those patients they need to see. And a lot of people have embraced virtual care. So they're trying to balance the concept of meeting every need. And the way they've done that is by listening to their patients. So if you're a landlord, listen to your tenants. And if you're a tenant, talk to your landlord. That's the simple answer.
Maybe we'll get rid of those automated answering machines next if we're lucky, but I doubt it.
We can only hope.
Fantastic. That's about it. If any final comments, we're right up against 4:30, so we'll cut it off there if not.
All right, here comes Alex, I bet.
Yeah, I just wanted to say thank you all for joining us today. As a reminder, we will be sending a follow-up email with the PowerPoint presentation and the webinar recording. Once this webinar is over, please take a moment to fill out our post-webinar survey. And thanks again, and have a great night, everybody.
So.